guys. My name is Alena Shautsova. I'm an immigration attorney from New York. And today we're going to have our the first live on YouTube after New Year's and holidays. And we're going to discuss the most recent immigration news. I'm going to share with you some interesting immigration news that I heard from my colleagues and online. We're going to discuss USCIS recent practices, going to talk about immigration court and what to do in the current situation with the tremendous backlogs. And of course, we're going to discuss topics that are interesting to you. So please save your questions. Say hello, first of all. Let me know where you're watching from. Join our live, start sharing. And of course, please type your questions in the chat. Hi, Yannick. Type your questions so I will be able to answer them in the end. After I will let you know everything that I know in the immigration world happening from Florida. That's nice. Hi, Yannick from Florida. Hi, Gab Freaks. Hi, Eloy. Hi, Musu. Hi, Christopher. Hi, Rohan. Hey, Manhattan is nice too. Hi, Y. And again, my name is Alena Shautsova, immigration attorney from New York. I help immigrants in all 50 states. I help those who are overseas, who get stuck overseas, those who would like to come to the United States from overseas. And of course, I help people here to stay united with their families, get employment, sponsorship if they're eligible, help you if you became a victim of a crime, VAWA filings, and so on and so forth. If you need to reach me, my website, www.shautsova.com, or call our office, 917-885-2261. And let's start. I see people joining, and hopefully it will be an interesting live. Don't forget to please ask your questions, and let's go. So first, what I wanted to call your attention for is that USCIS again extended flexibility, as they call it, in replying to various notices and decisions they are sending you. For example, you are an applicant for adjustment of status, or maybe some petition is filed on your behalf, and USCIS is sending you a request for more evidence, or USCIS denied your case, and you receive this denial, notice of intent to deny, notice of intent to revoke. USCIS again extended the time period during which you will have more time, more than standard 30 days, to submit your answer or motion to reopen or appeal. It's extremely important to know that the original notice that you're going to receive is not going to mention that you have this extra time. I still have people calling me saying, I only have 22 days left or 28 days left to submit my appeal to USCIS. You don't. You have more time. Now you have about up to 90 days from the date of the decision in certain situations, or 60 days in certain situations, depending on the date of the denial, to submit your appeal. And you have 60 extra days from the time when you have a deadline to submit your answer or extra evidence if you receive the request for more evidence. And how will you know that? It's not going to be printed in the documents that you're going to receive from USCIS. Well, because you're watching me, of course, and because USCIS publishes notices about that on their website. Okay, that's the only pretty much source of information. So this extra time, of course, gives you more time to prepare, to better prepare, perhaps to get documents from your home country, perhaps to work out a strategy with your lawyer as to what and how you're going to address. Very important to know that, because some people sometimes think, I got a denial, I'm going to pack up my bags and go home. Okay, because I have 30 days and there is nothing I can do in 30 days. Well, you don't have 30 days, you have more time. And there is almost all the time you can do at least something. So you need to know that you do have more time during the pandemic. Currently, they extended this flexibility up until March, almost end of March 2022. So watch out for that. Always consult with an attorney as to how much time you have to respond. Again, requests for more evidence, denials, notice of intent to revoke, notice of intent to deny. Maybe it's a denial of N400 and you need to file a request for a hearing. You do have more time. Extremely important. Of course, if you're watching my channel, you already know that those of you who are in healthcare industry can file now to expedite your guys' work permits if they're already expired or if they are expiring within the next 30 days. Extremely important. If you believe you qualify, file for it. There is no harm in asking, okay? No harm in asking. And who is a healthcare worker is being explained. It's a very broad term. It's also people, not only doctors, nurses, and assistants, it's also people who serve the healthcare industry. Even if you're serving the healthcare industry, you may be a driver, you would qualify for this. I mean, it's better than nothing. I personally think everybody should be able to do that, but it's better than nothing, right? Now, news, old news, but the backlog is growing. USCIS backlog is growing and growing. It has pretty much, according to some people, millions of cases that now are in USCIS backlogs, not looking good at all. And we see the backlog in immigration courts, even though immigration courts, I personally feel, got a little bit better because they're going on with the online hearings now. Not ideal, but something opposed to nothing. Because if they stop the hearings, at this point, the backlog from 500,000 something cases is going to grow to millions of cases, and we cannot have that. So interesting news that last year, USCIS wasted, the Department of Homeland Security, rather, all together, wasted 230,000 employment and family preference visas. This is crazy. Of course, these visas should be somehow recaptured and reused. For that reason, we have crazy backlogs in something like F4 category. If you're sponsored by your sibling, you are sponsoring your sibling, you'll see that the priority dates coming from 2007. 2007, what is it? It's more than 10 years at this point. It's how many years? 15, 16 years? This is crazy. So I hope they will clear up this backlog. It's very frustrating. And in 2022, unless USCIS is going to hire a lot of people, I don't think it's going to be improving much unless something there will be huge changes in organization and processing of applications. And that takes me to my next point. Many of you are aware that USCIS gives you an option to create a USCIS account. USCIS account, a good tool if you are checking it regularly. There are reports now that if you're going to have this USCIS account, all the notices for your case are going to be sent there and no longer going to be mailed to you or your attorney. And I personally have not experienced it yet, but it's a possibility. Lawyers do say that it's happening. They're saying that it's happening because USCIS is trying to, speed up the processing of the cases and get rid of the paper notices as it takes resources and times and blah, blah, blah. I get all that, but you need to know about this. So if you're creating USCIS account, make sure you stay on top of that account. Make sure those email notifications are not going to be kicked into a spam folder and you're going to miss something like biometrics or something important, notice for the interview, for example. And for that reason, I don't create those accounts just because I want the notices to be mailed to me. But you can do what you think is good for you. Now, we're going to also I'm going to share with you some tips about this tremendous backlog and, of course, state of the immigration reform. I know that many of you are worried about this. I see a lot of questions about immigration reform and what's happening with that. Well, I'm going to be honest with you right now. Nothing is happening with that. We know that Senator Manchin said that he will be open for negotiations with regard to BBB bill. And perhaps there will be a glimpse of hope for the immigration reform to go through within the reconciliation. For that, of course, they will have to override the Senate parliamentarian. Not sure if this is going to happen. Of course, there is always a traditional way to deal with the immigration reform, which is to pass the bill, but then we need to bring on board the Republicans, and also not sure if that's going to happen. There are executive orders, as many of you are mentioning on my community board, and I've been talking about them for a while as well. Sometimes you don't need to drastically change the system. You can just tweak it a little bit. That's all you need to do. For example, you can change the standard for the waiver. You can perhaps allow for the new waiver to happen, just like Obama did with I-601A waiver. Perhaps if such a waiver would exist for those who entered without inspection, that would save so much trouble. And I'm not talking about I-601 because that would require you to leave the United States and come back. And some consulates are good right now. They are processing cases. They move the cases fast, and some consulates are not. And of course, we see a lot of the trouble in Russia. I'm from Belarus, so of course I follow news from that region. All United States consulates are closed in Russia, and people are going to be transferred to Warsaw. And I can imagine the Warsaw consulate is going to be overwhelmed because Russia is a huge country, 144 million people. And of course, not everybody would like to come to the United States, but I can imagine a lot of people. And this is just shows you how inefficient the whole situation is. And it's going to stress out and take up the resources of Polish consulate, United States consulate in Poland. But it's happening in other consulates as well. They're not opened, or the processing, they give interviews at a very slow pace. And in other words, I-601A waiver, which is a great option if there is nothing else working for you, perhaps they can have I-601B that will allow you to get the same relief only without leaving the country, right? That would be awesome in my perspective. We'll see if it's happening. So my advice would be, by the way, to you guys, general advice, of course, is this: because considering the backlogs, and I know that it's going to take them a lot of time to clear those up, and uncertainty about the immigration reform, I know that many people are waiting, and for example, they are not asking their parents who have status in the United States to submit those I-130 petitions for them, family petitions. They're not asking their siblings who are US citizens to submit the petitions for them because they believe that it's going to take too long and it's never going to come. And do it, please. Do it. If you are unmarried, if you're not married, and you have a US permanent resident parent, they can file the petition for you, at least starting the process. Maybe later you can qualify for the waiver. Yes, it's going to take a very long time, but everything is taking a very long time right now. What if they do pass immigration reform that for a fee will allow you to speed up your process? Do not waste any more time, okay? Meet people almost every day who should have been sponsored by their siblings 10 years ago, and by now they would almost be ready to go for that waiver and get the visa. And don't wait. Also, if you have DACA, depending on when you receive DACA, you may not even need a waiver if you have an employment petition for you or current petition by a family member for you. If you manage to receive your DACA before you turned 18, you should not have any unlawful presence under your belt. And you should be able to travel to your home country, get a visa, and come back without the need of any waiver. Why? Unlawful presence time does not start running until person turns 18 years old in the United States. That's very, very important. Okay, so it may be your situation. So DACA stops unlawful presence. Filing for asylum stops unlawful presence. Filing for adjustment of status stops unlawful presence. These are just examples, okay? So you may have a chance of fixing your status, maybe not the way you planned initially, if you have certain conditions met. It's very, very important to know that. One more thing before I'm going to start answering questions. For those of you who are in immigration court, please consider filing administrative closure motions and motions to terminate. Two different things. Administrative closure stops your case. It pauses it. And you can keep your work permit if you have an underlying application pending, for example, asylum. Termination is the closure of the case in court. One client asked me, why would I want to terminate my case in court? Well, it's because it seems sometimes that it may be faster for you to do that and go for adjustment of status with USCIS than to wait for the new day in court, in immigration court, because immigration courts are overwhelmed and they may kick your case back several years, or like not back, like in the future, change your individual court date in the future. And you want to waste this time waiting for the individual hearing that may take years to come. I met one poor person whose master and individual hearings were canceled so many times that they have not seen a judge in 11 years. And a possibility, it's very rare, but it's possible. If I had to guess, I would say that an average case in court would take about 3 years to come to completion. Average case. It can be longer depending on the court, on the judge, and different circumstances. So considering those tools, administrative closure and termination, that both now are available because of the Biden administration, and they changed the nonsense that Trump administration established, saying that those tools could not be used by the judges. Very, very important. Okay, and now if you guys have some questions, I'll be happy to answer them. Let's go. Hi, Sadiat. Hi, Maria from Nevada. Hi, Jeffrix. Happy New Year to you and your family. Thank you very much. Hi, Jendra from Georgia. Hi, Manesh from Texas. Hi, Sukhinder from California. California is nice. Thank you, guys. Thank you, Zulu. Been waiting for the interview. Hi, Arun. I've been waiting for the interview for 6 years now for asylum case. 6 years, so you filed in 2016. Have you moved? Have you changed jurisdictions? Have you ever asked them to transfer your interview? I would say it's common. I wouldn't say that it's not uncommon nowadays, but I also think if everything goes well, you should be called for the interview this year or the next, because it seems if you filed in 2016, early 17, approximately this would be the time when you should be called for the interview, just because 16 cases were called for the interview, even some early 17 cases. Hi, Third Union. I know it's not your real name. I have received my confirmation letter for my interview. I uploaded my civil documents to NVC, and up to now, I still haven't heard from them. I'm from Jamaica. NVC haven't reviewed my case yet. Well, it depends on how long a time ago you did that. Typically, NVC says that gives them 90 days. 90 days for them to review your documents. Usually, though, I would say that within a month and a half, they should get back to you and tell you if it's document qualified case or not, okay? But Jamaican Consulate is open, so Jamaican Consulate is open. Hi, Ali. I've been working without authorization as an international student. Now I'd like to apply for EB3. Is it a problem? Yes. If you violated your student status, it means that, well, first of all, I would say, of course, because this is just general advice to you, you should consult with an attorney, but generally speaking, somebody who is in violation of their lawful non-immigrant status, they will not be able to adjust status in the United States unless an exception applies, 245K. They will have to see for how long you've been working without authorization, and if it's less than 180 days, then you may still be able to qualify for adjustment of status. So you need to consult with a lawyer, okay? They will be checking that, meaning USCIS. Hi, Ridwana. What about asylum interview for Bronx in 2017? Again, guys, I don't think there is anyone in the world who can accurately predict as to when, maybe apart from people with a crystal ball who know how to use it, they can predict when exactly you're going to be called for that asylum interview. I can only give you estimates, and again, something may change and I may be incorrect. I know there were lawyers in Brooklyn who would say, every month I get a list, I know who's going to be called. Baloney phony. Nobody knows, okay? Maybe apart from people who actually work for USCIS. And if they do, trust me, they're not going to tell it to everyone. So just judging by the cases that I've seen, I would say that it should be this year or next year, but that's just my prediction. What if, again, the officers are going to be called to work overseas as it was a couple of years ago, or to work at the southern border? That would happen to Newark officers. They had to reallocate them to work at the southern border to try to address the border crisis. And then, of course, people who are in New York, and if you're residing in the Bronx, most likely you belong to the Newark or New Jersey Asylum Office. You'll have to wait longer. So, you know. Hi, the promise on immigration was made by Democrats. Not doing nothing is really bad for them. The mid-election is around the corner and they only have this chance. I agree with you. I agree with you. The promise was made several times, very explicit promise, and it's a shame. It's a shame that one of their own now is saying that he's not convinced that people in the United States, you can take the route. It's like if people elected you guys both to the Senate and to the, House of Representatives, and the president is a Democratic president, I think it's a sign that people want you to make some changes that you promised to do, and not to act on those changes. It's really wrong. But again, I understand that there are precedents, and you cannot just disregard the other side. I'm never for that. This is a democratic country. You always have to listen to the minority as well, but negotiate. That's your job. That's why you're there. And it's been what, a year since the elections? Do something. I totally agree with you. Hi, I have been waiting for my asylum interview for 6 years. What can I do? A very similar question. To wait, that's number one. To prepare. You had 6 years to make your case as perfect as it can get. Remember this. So there will be no excuses for you if you go for that interview and you don't remember the dates. You cannot answer clearly and consistently and fully to the questions that the asylum officer is asking you. You have an obligation to present reasonably available evidence in support of your case, or explain why they're not available. Guys, extremely important. You had 6 years. This is just not to hang out here and work. It's also to prepare your case, because if you filed your case to begin with, I hope you were hoping to win it, right? If that's, I think, the goal of that is to win the case. So prepare, work on it, review it, see what else you can do. Make sure there is no stone unturned in your journey to get that asylum. It's not easy to win asylum case in the United States. The standard is high. The evidence you have to present are going to be carefully considered by asylum office and then by the judge. If you're referred to immigration court, you have to be prepared. Okay, you have to be prepared. So look at this as an opportunity to improve your case. You may face difficulties if your country conditions change drastically. And what happens is that, let's say your claim is that you were afraid of the government and now the government changed. It's new democratic government, right? Or so they say. Then you may face difficulties and you have to discuss it with your attorney. Do you have hope for humanitarian asylum? Can you still present expert testimony that, regardless of the fact that the main government changed, perhaps local authorities or people who are persecuting you did not change and still will do the same to you? Work on your case, okay? Try to make it better, but not lying. I'm talking about working on the evidence, finding every little piece of evidence that you can to make your case stronger. Hi, G, I have not received decision for 4 years after interview done with office. What do you recommend to do? Well, that's interesting. What kind of interview was that? Was it adjustment of status? 4 years is a little bit long, I would say. Are you sure you did not receive the interview? Did you check? Did you file for FOIA of your file? Sometimes it happens that the government said they denied your case a long time ago and you never received the decision. So make sure that you truly never received the decision, number one. Number two, well, start with a congressman's inquiry, right? Is your case pending beyond the processing times, which seems it does? Consider lawsuit if you want, but of course it has to be discussed with your attorney who knows better as to what's going on, why there is a situation. Were you called for multiple interviews or what's happening? You know, that's very, very unusual. I have to say it's unusual. What if people who left this year while waiting for reform? What if people who left this year while waiting for the reform? If the person left the United States, typically to come back, they will need a visa. However, if they accumulated unlawful presence here in the United States, they will need a waiver to come back. If this is your question, currently the law has not changed and there are no exceptions. There was a proposal by Biden at the very beginning, if you remember, who said that if you were deported within certain close time to the point of time from which, under his proposal, you would qualify for some benefit in the United States, you would be allowed to apply for those benefits. But that was just initial proposal by Biden, never became the law. And currently, if you leave the United States, my prediction would be that you will not be able to come back for 10 years if you've been here and accumulated unlawful presence time for more than a year. So considering, consulting with an attorney before you do anything. Hi, Arun, can you apply for a green card through work if I already have an asylum application pending? Asylum application pending is not lawful non-immigrant status. If you would like to file for any adjustment of status in this situation, you will have to argue an exception to the general rule that you cannot adjust your status in the United States if you fall out of status. You have to show that this failure to maintain your status was to no fault of your own. Some people are using method of MK. I don't remember. I don't use it. I think it's too risky to do it in New York, but perhaps some lawyers, depending on where you live, will be able to show you proof that they win cases this way, and then go for it if this is a situation that applies to you, where you can successfully argue that exception to the general rule that you cannot do that. Okay. Hi, Bonzas. Hi, Ikinis. Happy New Year. Hi, Hope. Hello, Alena. I came to this country in 1999 with a crew member. I'm not legal here. Do you think I have a chance to be legal here? Well, if you have C1D visa, generally speaking, you're not eligible for adjustment of status or cancellation removal. I believe so that the only route would be a waiver, I-601A waiver, if you are going to be married to a U.S. citizen or have a child who is 21 now, can sponsor you. That would be the first thing that comes to mind. But again, depending on your situation, there can be something else. Perhaps you would qualify for 245I exception, or your spouse did, and now you can benefit from it. If you were married to them prior to a certain date. So I would say consult with a lawyer just in case. It's worth it. It's worth it to check what can be done. Hi, Sharov. My I-45 family-based case filed in April 2018, and the interview was completed in September 20. Okay, 20. Now, more than a year, no decision by USCIS. You have to follow up with them, right? You have to follow up with them, submit a congressman inquiry. I feel those inquiries are very, very effective. Okay, very effective. Hi, Mohammed. When can I get work permit under BFD determination for U visa? I applied in July 2018. In my community board, I posted an explanation about BFD determination and U visa. And if you read it, you will have your answer. First, you have to get the BFD determination, and then depending on Maybe your lawyer submitted for work permit already as a part of the application. Some lawyers did do that, depending on what time you were submitting your applications at, or perhaps you will have to submit a separate form I-765 after you get the determination. Hi, Ivan. I overstayed visa 7 years ago. Should I go to a lawyer or it doesn't make any sense? Well, it depends on what you want to do. If you think that, you would like to have a definite answer as to what your situation is, maybe you were married, maybe you divorced, maybe you became a victim of a crime, maybe something else, you can do that, right? If you think that you maybe don't want to do that, it's totally up to you. Lawyers, basically professional lawyers, will tell you the truth as to what you can or cannot do, and that's it, right? So if you'd like to know the definite answer to your situation, then of course consult with an attorney. If you'd rather save your money and wait for something to come in the news where you think you have better chances, then wait for something. It all depends on you. If you have any family members in the United States, if you were filing before for something, if you became a victim of a crime in the United States, then I think it makes sense to consult with an attorney to see if you have any chances. Okay. Hi, Hussein. Hi, Alena. I'm seeking asylum February 2015. Still, I don't have a date yet. This is crazy. Is it true that if someone wait 10 years or more for asylum, they get some waivers to approve? No. Nobody's going to approve your asylum case just because you were waiting for it for too long. That's definitely not true. What happens is this. First of all, if you filed your asylum case much after your 1-year deadline, USCIS may send you a document saying that you may waive your interview and they will send you to court directly. Do you want to do that or not? If you do want to do that, send us a notice that you do, and we're going to waive your interview and send you to court, and the court is going to deal with you. You can choose to do that. Why would you choose to do that? I'm going to tell you why. Because some lawyers were consulting their clients saying that if you lived in the United States for 10 years first and you file for asylum case is extremely weak. You can go to court and in court switch your case from asylum to cancellation of removal. And for cancellation of removal, you have to show that you resided in the United States continuously for 10 years from your entry, and you have a qualifying relative who is going to experience exceptional, unusual hardship in case of your removal. And in the discretion of the court, you deserve cancellation of removal or adjustment of status before the court. It's called cancellation of removal. It's very similar. It's basically adjustment of status, but legally a little bit different. And that's why some people filed their asylum cases way after their 1-year deadline. Then they're hoping to be transferred to court. And rather than fighting for their asylum cases, they're going to be fighting for cancellation of removal. Maybe that's what those people mean when they told you about the waiver, okay? But no, nobody's giving asylum cases without the interview at the asylum office. Never heard of it. I'll be honest. Hi, Annette. Do you know when they are calling for interview for N400? I think it depends on the jurisdiction where you reside, and from what I've seen, when you filed for your case, from what I've seen, currently takes a year to be called. Okay, in New York, maybe where you reside, it's different. Hi, Vinay. Happy New Year to you too. Are they going fight continue for undocumented people which are in the United States by the Democrats? Please let me know. I totally think that it will. I know that it will. The only question is that whether it's going to happen now as a part of the reconciliation, because I think it's a very good chance and you can really not waste it if you're truly worried about people who reside here. You have the power to do that. You have the momentum. You have to go for it, right? If not now, then they will have to either resort to executive actions and regulations and or go for a traditional bill, which will be very difficult to pass. I would, if I were them, but of course I'm not them, who's going to listen to me? But they can look at those proposals that were done by the Republicans previously, and that would be their negotiation point. Of course, then you have to leave your pride behind you for that. But for the sake of the people, I think they should be doing that and working with the Republicans. You know, those proposals, as you recall, would include usually a fine for those who undocumented here as a condition of applying for some status. Usually they would also have some sort of a temporary status before you're going to be able to file for a permanent residence, which in this situation, I think I would take anything. I mean, I don't know about you, but if it gives me a work permit, ability to travel, right, while I'm waiting for the pass, and it's not ideal, I'd take it. Because some of those proposals, guys, came out in 2013, and it's been like almost 10 years, and nothing is done. So yeah, I personally would take it and then would ask for more. That's my position. But you know, but will they fight? I'm sure they will. Immigration in the United States became a very strong political point, so they will fight. Hi, Diego. Can DACA recipient without legal entry get a green card throughout employment? My fast answer would be probably not. Okay, probably not. Green card without entry means that you know, it's not even the entry; it's the fact that you haven't maintained your lawful and immigrant status as well, unless there is also some exception involved. But I would suggest you speak to a lawyer in private to discuss that, because here I can only give you a general situation, right? Traditionally speaking, to adjust your status based on employment, you'll have to show, of course, that you were inspected and admitted, and that you maintained your lawful non-immigrant status throughout the point of in time when you were inspected and admitted to the United States. Now, there are some exceptions that some people may qualify for, like 245I. Rarely, but it's possible. I find clients every now and then who do, and it makes me very, very happy. All right, guys. So thank you very much for watching. It's been about 40 minutes we were together. Kind of getting late, but I was very, very happy to see all of you. Again, you can play this back to follow the advice about immigration court, administrative closure and termination. Consider this. If you're in immigration court, it will be a good time to ask for it. Very, very important. Also, do not wait. If you have family members who can submit those petitions for you, I-130 petitions, please talk to them and go ahead and do that. The faster you do it, the faster the time is going to pass. Also, one more thing. I think that some people have this fear that if one family member files for them, then the other one cannot, or the employer cannot. This is not the case. Each petition is separate, does not interfere with each other, unless, of course, there is some fraud involved, which I hope there is none. So thank you very much for watching. It was a pleasure. Don't forget to subscribe to my channel if you have not. And we are going to have our next live next week. And I hope to see you soon.